Well, we got some breaking news and developments in the case involving Melania Trump on one hand and journalist Michael Wolff on the other. In October, Michael Wolff filed first a lawsuit in New York State Supreme Court in Manhattan, trial court level, for a declaratory judgment to cut Melania Trump off at the pass after he received a demand letter.
Some legal disputes do not gain prominence because of their immediate gravity, but because of the way they strain the formal mechanisms of the system. At the end of October 2025, a seemingly civil case with limited scope began circulating between the state and federal justice systems in the United States, involving former First Lady Melania Trump and writer Michael Wolff, initially classified as a lawsuit based on freedom of expression and allegations of defamation. The case soon began to cause a specific type of friction between institutional spheres, a dispute over jurisdiction. The plaintiff filed the lawsuit in the New York State Supreme Court, claiming that he resided in the state and that Melania did as well. The defense, in turn, claimed that the former First Lady's permanent residence is in Florida, invoking the principle of diversity of citizenship to request the removal of the case to the federal district court in southern New York. Although the dispute appears technical, its immediate consequence is the triggering of legal mechanisms that could lead to formal steps, such as the production of evidence, the collection of records, and sworn testimony about the private life of a public figure with direct ties to the center of political power. The impact of the episode was not limited to what was presented in the court records. The move to remove the case from the state sphere, coupled with Melania's failure to take direct action against the author, raised questions among legal practitioners. Michael Wolff claims that he was the target of letters sent by the former First Lady's legal team, demanding retraction, an apology, and financial compensation under threat of $1 billion defamation lawsuit. Instead of retracting, he took action, based on New York State legislation known as anti-SLAPP, which protects journalists and citizens against lawsuits considered attempts at intimidation. The legislation, although little known outside the legal community, is increasingly used in disputes involving public figures and content published on open platforms. The defense's position, however, was not to address the merits of the case, but rather to transfer it to federal court, alleging that the state court was not appropriate to hear the case. This move led to the formalization of a new phase of the lawsuit, no longer focused on allegations of defamation or freedom of expression, but on defining the former First Lady's legal domicile. In claiming to be a resident of Florida, Melania presented evidence: the fact that she has been registered to vote in the state since 2019, has a local driver's license, and lists Mar-a-Lago as her official residence on federal documents. Wolff, however, maintains that she resides in New York, at Trump Tower, where she has been located on several occasions, and where the plaintiff unsuccessfully attempted to personally deliver the subpoena. The disagreement between the parties is likely to lead to a request for jurisdictional discovery, a legal procedure that authorizes limited collection of documents and testimony to determine the appropriate jurisdiction. If authorized, this process would include requesting flight records, proof of residence, and possibly a formal deposition from the former First Lady about her travel routine and usual place of residence. In this context, the connection to the Epstein case began to circulate as an informal backdrop, although it still had no direct impact on the merits of the case. Photographs of Melania at social events, alongside Jeffrey Epstein, Ghislaine Maxwell, and other associates, have recirculated, reinforcing the plaintiff's narrative that there is legitimate public interest in investigating and reporting on the nature of these relationships. The defense, however, maintains that such images do not constitute evidence, and that any attempt to associate her with the scandal represents damage to her image. The use of these images and mentions in articles published by the author is part of what the defense classifies as false and malicious allegations. But so far, no defamation lawsuit has been filed by Melania Trump against the author, which reinforces the perception that the strategy adopted is one of procedural control, rather than direct confrontation of the content. The documentation also included information that Melania had threatened to sue other public figures, including Hunter Biden, for similar amounts, but again without formalizing any action. The recurrence of this pattern, threats of lawsuits with significant amounts, followed by a lack of legal action, has been observed by analysts as a possible attempt to demobilize critical coverage without exposing oneself to the risk of discovery in the assessment of lawyers following the case. The absence of formal proceedings may indicate fear of producing evidence, or the need to testify under oath, although there is no formal evidence of obstruction, the set of legal and extrajudicial maneuvers seems to follow a strategy of containment, prioritizing procedural matters over directly confronting the allegations. It is in this scenario that institutional observers turn their attention to the role of the Southern District Court of New York, a court that has already played a central role in cases involving Jeffrey Epstein, Ghislaine Maxwell, and other high-impact cases involving public figures and federal crimes. According to the Department of Justice, the court holds a collection of more than 1 million records related to the Epstein case, many of which have not yet been released. The coincidence between this jurisdiction and the choice of venue made by Melania's defense is not ignored by analysts, although there is no formal evidence of an attempt to control the content of the files. Still, the overlap of instances, names, and themes suggests that any procedural movement in this court may reverberate beyond the specific case by bringing to light the legal provisions invoked, the criteria for jurisdiction in dispute, and the absence of direct action on the part of the defendant. This case fits into a broader context of tension. Invoking the diversity of citizenship clause as grounds for transferring the case to federal court is not merely a technical recourse provided for in US law. In practice, it functions as a cog in the legal system, a cog that takes center stage whenever there is a dispute over which court has jurisdiction to hear a case. In this sense, what we see in the clash between Michael Wolff and Melania Trump is the deliberate mobilization of this cog. As a first line of defense, the defense chose not to directly address the content of the lawsuit, a lawsuit based on New York State's anti-SLAPP law, but rather to shift the litigation to a space where interpretations of freedom of expression, defamation, and damage to reputation can take a different course. The choice of venue is not neutral. State and federal courts, although they share broad legal frameworks, differ in case law.
You don't hand matches to an arsonist, and you don't give power to an...
Institutional connections gain additional layers. The Southern District Court of New York, where the removal request is pending, has in recent years become a key player in highly complex cases involving public figures, networks of influence, and confidential documents. It was there that the criminal proceedings against Ghislaine Maxwell and Jeffrey Epstein were concentrated, including the collection of more than 1 million records related to the case. The Department of Justice recently confirmed that a significant portion of these
6 weeks
documents remain
ago
in custody, under review, with partial release still pending. References to this collection, made at different times by specialized media outlets and lawmakers, have increased attention on any movement involving that court's jurisdiction, especially when the names of Trump, Melania, and other members of the presidential circle appear, tangentially linked to previous investigations. This convergence helps to understand why the simple transfer of the case is seen by analysts as more than a technical gesture. The choice of federal jurisdiction, especially in that court, reactivates recent institutional memories of how evidence, testimony, and sensitive protocols were handled.
Members
in
are
previous cases.
directed to uphold and maintain decorum in the House and to cease any further
the Epstein investigations. The procedural environment in which the case is set inevitably carries this background: the court's history, the sensitivity of the names involved, and the confidential records establish a backdrop that interferes with the institutional perception of the case, even when the immediate merits concern threats of defamation lawsuits. The anti-SLAPP legislation, invoked by Wolff as the central basis for his action, aims to protect freedom of expression against attempts to silence it through litigation. It has gained prominence in recent years as disputes between journalists and public figures intensify, particularly on issues of collective interest. In New York State, the version of the law allows the plaintiff to request early dismissal of the case if they can demonstrate that the lawsuit against them was primarily intended to intimidate or repress the legitimate exercise of expression. It is at this point that the case takes on another institutional dimension. The court will have to consider whether the letters sent by Melania's team, demanding retraction and threatening $1 billion lawsuit, constitute an attempt to unduly constrain freedom of the press. This consideration is particularly sensitive when the central figure in the controversy is a former First Lady of the United States. The Constitution and judicial precedents recognize that public figures are subject to a higher level of scrutiny, and that, therefore, the barriers to establishing defamation against them are higher. This is due to the principle that public debate should be free and vigorous, even if it involves harsh criticism or speculation. The US Supreme Court has already ruled in precedents such as New York Times, Crumber vs. Sullivan, that defamation against public figures requires proof of actual malice, that is, a demonstration that the information was published with knowledge of its falsity, or with reckless disregard for the truth. This requirement makes the path to a defamation lawsuit more restricted, especially in contexts where the content discussed involves public records, photographs, and indirect links to events of public interest. It is in this arena that the institutional tension unfolds. And the protection of journalistic expression, represented by Michael Wolff, reports that attempts to serve legal notice were systematically thwarted, with refusals by security guards, and the inability to locate the former First Lady raised questions about the party's willingness to deal with formal procedural rights. If it is confirmed that there was repeated resistance to the delivery of the notification, this could be interpreted by the court as an attempt to indirectly obstruct the regular progress of the lawsuit, even if not explicitly. The alternative adopted, direct appearance in federal court with a request for removal, can be interpreted as a strategy to anticipate jurisdiction and avoid direct confrontation with state law. At the same time, the move occurs in a broader scenario of institutional reassessment, of the limits of discourse, the accountability of public figures, and the role of the press in polarized contexts. Litigation over freedom of expression has grown in the country, especially in cases involving celebrities, politicians, and issues related to past conduct. The way courts interpret this type of litigation, especially when it involves previous threats that did not materialize, can set precedents that impact similar future disputes. In this specific case, the absence of a formal lawsuit by Melania, despite the explicit threats and the significant amounts mentioned, could be interpreted as a sign that the initial objective was to dissuade, not to litigate. This point, if accepted by the judge, could weigh on the analysis of the legitimacy of Wolff's action and the decision on its permanence in federal court. The instances involved, the legal grounds invoked, and the overlap with jurisdictions marked by previous highly sensitive cases make this process a kind of informal test of how the legal system responds to tensions between reputation, public image, and freedom of expression. Although the merits of the defamation charge are not formally on trial at this time, the procedural elements and institutional movements already constitute a relevant field of dispute for understanding the self-defense mechanisms used by public figures and the limits of such use when confronted by journalists. Continuous reading of cases such as this offers a valuable window into how the legal machinery works under tension. Following these developments allows us to understand not only the outcome, but also the paths and choices that define how the system responds to sensitive disputes. By keeping this type of analysis in focus, the channel seeks to offer the public a more accurate understanding of institutional functioning. The decision on whether to keep the case in federal court will continue to depend, among other factors, on how the court assesses the arguments presented by the parties regarding Melania Trump's legal domicile. In this regard, interpretations remain divergent. The defense maintains that the documentation gathered, including her voter registration in the state of Florida, her driver's license issued by that state, and the indication of Mar-a-Lago as her residence, constitutes sufficient evidence to characterize the domicile required for the removal of the case to federal jurisdiction. In contrast, Michael Wolff's attorneys argue that these elements do not rule out the possibility that Melania maintains her primary residence in New York, where, according to this line of argument, she would reside more consistently and where she would have been located. For the purposes of service of process, in this interpretation, occasional stays at Mar-a-Lago or the fulfillment of social commitments there would not be sufficient to disqualify her as a New York resident. At the time of filing, the legal debate therefore focuses on the technical concept of domicile in US law, which goes beyond simple intermittent physical presence. It requires proof of effective intention to remain, a stable pattern of residence, and concrete daily ties to the place designated as the primary residence. In disputes of this type, it is common to use a specific procedural phase, known as jurisdictional discovery. At this stage, the interested party may request the presentation of documents, financial records, proof of residence, and even sworn testimony from the opposing party in order to clarify their actual housing situation. If the judge authorizes this step, Melania may be formally summoned to provide detailed information and answer objective questions about her routine, such as the distribution of days between states, the frequency of travel, and the location where she keeps her personal belongings. Legal analysts note that if this investigation phase is admitted, the process may take on new contours, both procedurally and politically. This is because documents and statements produced at this time, even if officially restricted to the discussion of jurisdictional competence, may end up revealing indirect connections with other sensitive areas questions related to her presence at Mar-a-Lago, her association with certain public figures, or her participation in events associated with people linked to the Epstein scandal, for example, could reactivate links that had previously been treated as secondary, although such elements do not, in themselves, constitute grounds for prosecution. Their possible incorporation into the proceedings tends to increase the level of public exposure of the former First Lady, especially in a judicial environment already marked by high-profile cases. To date, there is no consensus among legal experts as to the predominant motivation of the defense in opting to remove the case to the federal level without, at the same time, proposing a defamation suit. Some experts interpret this choice as a strategy aimed at neutralizing Wolff's initiative, seeking to weaken its foundations through strictly procedural arguments. Others see Melania's absence of a direct claim as a sign of caution, given the risk that the discovery phase may expose information that the defense would prefer to keep out of the court's reach in any of these interpretations. The debate goes beyond the simple correction of allegations or the preservation of image, reaching the operational limits of litigation when it involves people associated with political power and public debate. The way the case has been conducted, with the defendant accused of attempting to intimidate a journalist by focusing its response on the definition of jurisdiction, rather than addressing the merits, has been the subject of reflection in specialized legal circles. Some argue that this type of strategy, although formally legitimate, contributes to shifting the focus of public debate, diverting analysis away from the content of the publications, and directing attention to procedural issues. Instead of discussing what was said, written, or disclosed, the center of the controversy becomes who has jurisdiction to judge of the regular functioning of the legal system. Their repeated use in disputes involving the press and public figures has led experts to reassess the scope of anti-SLAPP laws and the limits of defensive litigation according to public statements attributed to Michael Wolff. The absence of a formal response from the defense to the content of his allegations would reinforce his assessment that the initial initiative was not primarily intended to litigate, but rather to exert pressure to silence. Melania's legal team, in turn, maintains that the published texts exceed the limits of freedom of expression and that, for this reason, the case should be analyzed from the perspective of damages. To date, however, the court has not ruled on the merits of these positions, focusing its analysis on the admissibility of the removal and criteria related to domicile. The situation remains unclear. If the court concludes that Melania is indeed a resident of the state of Florida, the case will remain in federal court and may even be dismissed by a motion to dismiss before any discussion of the substance of the allegations is addressed. If, on the other hand, New York residency is recognized, the lawsuit will return to state jurisdiction, where anti-SLAPP legislation tends to be applied more broadly. In either case, the conduct of the lawsuit is likely to influence future debates on the limits of freedom of expression, the strategic use of the judicial system, and the institutional protection of journalistic activity beyond the individuals involved and the specific circumstances. What is noteworthy is the way in which the legal system responds to disputes that combine public image, institutional memory, and discursive responsibility in a context in which public figures frequently resort to legal instruments in response to news reports or investigations. The way in which courts balance individual rights and collective guarantees plays a central role in the institutional narrative. The case involving Wolff and Melania Trump remains ongoing, and its future developments may or may not contribute to strengthening criteria of transparency and proportionality in the relationship between political power, the press, and the justice system. Episodes of this nature highlight the importance of continuously monitoring institutional developments, not only to understand the facts, but also to analyze how systems react. Keeping this type of observation in perspective is essential to assess the functioning of democratic mechanisms in the face of growing tensions between public discourse and legal accountability.